What's up, family? It's the People's Paralegal, legally trained, street approved. Right now, the Karmelo Anthony trial is in jury selection in Texas, and the racial tension is already thick. But before the first witness even steps up, the streets are already misinterpreting the law. Let's talk about how Texas self defense actually works because it's not what you think.
We want to go back now to our lead story, which is jury selection beginning in just a few hours in the trial of a North Texas teen accused of stabbing and killing a student athlete. 19-year-old Karmelo Anthony is charged with the murder of Austin Metcalf. Trevor Sohaki is live for us this morning outside the Collin County Courthouse this morning with the very latest on this case. And Trevor, this case has actually captured the national attention, particularly on social media, too.
Yeah, that's right, Carmen. There have been debates online over stand your ground laws, race, and lots of misinformation on social media. In fact, there's been so much tension, threats, and controversy that the judge issued a gag order last year to prevent either side from discussing the case. Now, police say this stabbing happened at a Frisco ISD track meet in April of last year after a verbal confrontation between Karmelo Anthony and Austin Metcalf. A witness told police that Anthony came over to Metcalf and others in a tent on the bleachers. The 17-year-olds went to different schools and didn't know each other. Metcalf told him to leave. Then Anthony reached into his bag and said, "Touch me and see what happens." One witness said Metcalf touched Anthony, and another witness said Metcalf grabbed Anthony. Police said that's when Anthony pulled out a knife and stabbed Metcalf once in the chest before running away. Metcalf was taken to the hospital where he later died. Anthony was later arrested and charged with murder. According to a police report, Anthony admitted to the stabbing, claiming it was self-defense. He's currently on house arrest at his parents' home. Now, jury selection will begin at 9 this morning. Collin County District Judge John Roach is not allowing any live streaming of the trial inside the courtroom, but we will have a reporter inside that room at all times. We'll bring the very latest updates as they come in. Live in
Okay. What's up, y'all? I'm the People's Paralegal. It's your boy E.B.H. Black. First of all, I am not an attorney. I am a paralegal. So this is not legal advice. This is for educational purposes and entertainment purposes only. I do have 2 degrees in criminal justice. I do have um, a degree in paralegal studies. I worked in criminal law, family law, intellectual property law, workers' compensation, pro athlete workers' compensation. So I do have a little bit of insight. And I also graduated from the School of Hard Knocks, the Oakland, California campus. So let's lock in and see what's going on with this court case, with the Karmelo Anthony case. It's going to be really, really polarizing. So I thought that I'll come and share some insight from a street perspective to help people that don't necessarily know the law like that understand the law. So that way, when the outcome comes out the way it does, then maybe you will understand a little bit more of how the law works. Because one of the things I've learned is ignorance of the law is no excuse. So if you get caught up by the law and you don't know the law, there's no excuse. Let's get to it though. So we're going to talk about the Karmelo Anthony case. Essentially, what happened was Karmelo was at a track meet, and it started raining, and he went under a tent. And while he was under the tent, he was under an opposing team's tent. It wasn't his own tent, and he got into a confrontation. And the confrontation ensued. They got into it between Austin Metcalf and Karmelo Anthony, and Karmelo Anthony tragically unalived Austin Metcalf. But let me say firstly, though, I'm team no one. I'm team no one because I'm going to postpone judgment. That's the number one thing I learned in law was postpone judgment. And as the facts come, then you upgrade your opinion, and that way it's based on facts and not how you emotionally appeal to it. So I would ask you guys to do the same. We can kind of make some, judgments or some spot some things out, but as you're doing those things, don't assign it to guilty or not guilty yet until you get most of the facts, if not all of the facts. So yeah, we're going to be in juror mode. So you guys know pretty much what happened in the case, and we'll break it down more intently as the case goes on, and probably like in opening arguments. But there's a lot of racial tension, and from the street perspective, the tension is there because, as you always hear, no justice, no peace. And so people want justice, and they want Karmelo to have a fair trial, because it's been known that we've been misrepresented in the court of law, and we just want to have a fair shot at justice. So what does justice look like? That's what we need to figure out. And we're going to figure that out on this channel, because I'm going to help you guys. So initially he was held on $1 million bond. 12 days after the incident, a judge reduced the bond to $250,000, citing factors that included a lack of prior criminal record, was not a flight risk, or a danger to the community. This brought up some issues too, because when they first gave him a bond, it was $1 million. Prejudicial. And so, which was probably a standard practice somewhat. It was in the range, and then they usually reduce it, and that's what happened. Consequently, the judge that did it reduced the bond or the bail, and was black. And so they doxed her and made that situation kind of very tense there already. So there's racial underlines here, because it's obvious it's a black guy and a white guy, and the white guy died. So it's going to have some racial undertone. And even if it was the other way around, it's going to be the same way. Another thing that came up was the funds that Karmelo Anthony raised. He raised, it looks like up to now, $600K at the Give Some Go. And both sides did as well, because Metcalf raised about $250K. But the issue that was underlining with that is, you guys are trying to fund a murderer, as he was being called at the time. And black people were like, you guys raise money all the time, and when we raise money, it's an issue. So the money was supposed to simply help the family get a good defense. Because, as you should know, is the level that you can pay for your lawyers, that is the better the chances are you can get acquittal. Look at O.J. Simpson, the Dream Team. He put all his funds together, and he made sure he got the best lawyers out there that he could, and it worked for him. And that doesn't necessarily just work in that situation, but it works in your everyday situation, because if you pay for an attorney versus a public defender, then of course you're going to get better representation from the lawyer that's not the public defender. That's not always the case, because I know some good public defenders, and they're simply trying to work their way up and trying to get themselves established as well. So all public defenders are not bad. So black people were feeling like they're being bullied by white people, and simply just calling him a murderer, and not knowing the situation. And as things came out, it just divided people. And then for white people, I would say it's a sense of black fatigue. They're tired of the mentality that they're seeing online. I know you guys see it. I see it all the time. It is tiring to see that, because that represents a culture. And so when other cultures see that as the culture, then they have an inherent fear, or inherent bias, or inherent perspective about you. And then we might look at it and say, hey, that's being prejudiced or racist. And then now it's at the point now white people call black people racist, which never used to be a thing, but now it is a thing. Well, we're going to look at the courtroom perspective. Let's look at the charges. So here's the charges. Penal Code 1902, first Penal Code 1902, subsection C. It's important that you look at those subsections because those subsections are very, very important because it tells you where to go to see what applies. Because what's important is you need to know what rules of law is applied. So 1902C, first degree murder. And in that, you will see that it breaks down what is the standard and the burden of proof for murder. Now, the burden of proof in this case is going to be on the defense. I mean, it's going to be on the prosecution. And I know a lot of people may think that it's usually on the defense to defend yourself, but this is a stand your ground case. So the burden shifts to the prosecution. They have to prove that this person really wasn't in fear of their life and they didn't think that they were reasonably being attacked. So if they can prove that standard, then this person will be guilty of first degree. But we're going to have to pay attention because there's a subsection in there that also cover other things. Because the only thing we're hearing right now is first degree murder. Now, if that was only the only charge, then you would simply have to beat that burden and you would be free. But in this case, he has other underlying charges where he can get charged with manslaughter, or another crime like a crime of passion. So those are different levels, and they'll have different sentencing as well. So this is a self-defense claim. And one of the important things that you'll see or hear is provocation. What is provocation? Pretty sure it's exactly like it sounds. Okay, yeah. Just want to make sure everything was good. Okay, provocation. That's a word you're going to hear a lot during this court case is about provocation. And that's a standard on the standard ground case because the person that is claiming self-defense cannot have provoked the other person. You can't provoke somebody and then when they retaliate and then you take out a weapon or you stand your ground at that point. No, you incited it all. You were the provocateur. You provoked it. So that's going to be very important because people are going to want to understand. Well, the jury's going to want to understand who provoked this. Now, one of the things that came up was he hit me. What he says when Karmelo says hit me and see what happens. As has been stated, is he was pushed. Karmelo was pushed by Austin Metcalf. And then Karmelo reached in his bag and was like, hit me and see what happens. And then there was a confrontation. This is going to be a key point in the court case because how do you hear that? There's a couple different ways you can hear that. If you're from the camp of Carmelo Anthony, what you hear is do it again and find out what happened, like FAFO, right? So if you do it again, then I'm going to defend myself. Like, even as a child was taught that. Somebody hit you, hit him back. He was pushed. So maybe Karmelo didn't feel like he was at that point where he would fight him, because he's not like he maybe was a thug, because all he needed, and this is me speculating, but all he would have needed was that to jump on him. But he was being patient. That's what it appears. And he was just simply saying, hey, look, check this out. If you do that again, see what happens. And then we saw what happened. Now, if you from the Austin Metcalf camp, that sounds like provocation, because you're saying to me, do something to me, do something to me, like you're enticing me to do something to you. So that way, if I do and you retaliate, it goes back to what I was saying about the stand your ground. You can't claim stand your ground if you were the provocateur. And they're saying that those words provoked them. That is what the jury is going to have to parse out. I have my opinion about it and I'll share it, but let's get to the bare facts right now, because we're at the jury phase where they're selecting the jury. Just want to give a little background, because I'm going to follow this case and I'm going to show you guys things in real time, where how the media may turn this and put that little slant on it, or how this is interpreted in the law, not how it sounds, because it may sound like this to a layperson or common sense, but in law, it means something else. So I'm going to be here to help you guys through that, and hopefully it'll help you guys look at further cases a little bit more intelligently and legally, more important. So Texas, they have some of the most misunderstood laws in the country. Streets think stand your ground means you could just go off if somebody disrespects you or whatever. But people usually think that the defense have to prove it, but the prosecution has to prove that the defendant is guilty. So here's a big misconception: who has the burden? So if you're in the camp of Carmelo Anthony, they think because Austin Metcalf put his hands on him first, right? By either shoving him, grabbing him, touching him, it doesn't even matter. Carmelo automatically had the right to use force to protect himself. In this case, including a knife, under the stand your ground, but that's not what the stand your ground says. Texas Penal Code section 93, 9.31 and 9.32 it states what the stand your ground precedent is. Now, in 9.31, that established the general right to self-defense. Well, 9.32 covers the use of deadly force. Together, they remove the duty to retreat if you are legally present and not engaging in criminal activity. So let's look at this. It talks about generally, hey, if you have a legal right to be there and you're not committing a crime, you have the right to stand your ground. Okay, that's what establishes it. Now, they go on further to tell you what force is necessary that you can use. You generally, and this is generally in all states, but make sure you check the state that you're in, that you meet force with force. Or if you reasonably thought that you were in great bodily harm, injury, or death. So if you can prove that, then you are clear for self-defense and stand your ground. So that's going to be the question. So one hot button word is proportionality. And this is a question that a lot of people have. You can't bring a gun, you can't bring a knife to a fist fight unless you just reasonably think that you're going to face a deadly force or seriously bodily injury. So that's going to be the $1 billion question, y'all. The jury has to answer. Was Karmelo in the right for using the force that he used. Some might debate that he was being bullied by a group. That might be one of the defenses. I heard some things about that. His twin brother was there. He might feel like he was going to get jumped. There's some things that we're going to see in court what the reasoning is, and if they can articulate that, then he would be clear of it. And back to where I was talking about provocation. So according to the police reports, the words were exchanged. Karmelo reached into his bag and allegedly said, "Touch me and see what happened." And I just discussed that. Depending on how the jurors hear that, that's going to determine who provoked it. Was Karmelo provoking him to do something to start a fight so he can finish it? Or was he giving him a warning and he crossed that boundary of the warning and then the situation ensued? Now, this is just me. This is Black saying what I think, just little pieces that I pay attention to is if Karmelo was pushed first and then he said what he said and then he was pushed again and then it happened, to me, reasonably, to me, that sounds like, okay, I wasn't provoking you because you already pushed me. So there's no me provoking you. And if you're saying I provoked you more with those words, you've already crossed that boundary. I didn't provoke you. What provoked you was I was under your tent and I wouldn't leave because you said so. So looking at it from that standpoint, from just, my professional, unprofessional opinion, that's something that is going to be something that the jury need to look at. So under Texas law, self-defense is an affirmative defense. You know what an affirmative defense is? Affirmative defense is like, it's a legal strategy where a defendant admits to committing the physical act or the crime, but presents a circumstance that legally justifies, excuses, or mitigates the behavior. For example, like if you can find a reason why you legally could do it under the law, then you are going to be held like for free. You're going to get off free because there's usually certain affirmable defenses, like affirmable defense for murder. Let me think, like if somebody attacks you first, like stand your ground, basically, like stand your ground. If somebody violates you in that way and you use that force to defend yourself, then you are under that affirmable defense. So, and then also under this, you can also mitigate the behavior as well, because right now they're trying to say it was first degree murder. First degree murder is like premeditated murder, malice aforethought. But I mean, you thought about it before you did it, and in your state of mind, your intentions was bad. Like they would have to prove that, and if they can't prove that, they'll try to mitigate it down to other things. So, but now the thing about it is, if no provocation is proven from Karmelo Anthony, then I'm sorry, if they from Karmelo, if they prove that there was none for him, he has to go. But if they do prove that he was the one who provoked it, then simply there's no self-defense claim. All right, so the defense don't have to prove that he acted in self-defense. They just have to produce a little bit of evidence to suggest that he was protecting himself. And all they would have to say is something like, him and his brother ganging up on him, or just some circumstances. It's a low standard that he really could possibly feel that way. And then once that happened, the burden flips. It flips from the defense to the prosecution. Now the prosecution has to be, the state has to be the one to prove it beyond a reasonable doubt that it wasn't self-defense. So that's just like saying the defense passes the prosecution the ball. The prosecution has 100% pressure on them. 100%. Carmelo Anthony don't have to take it, and they don't even have to put a case on it in rare situations, and it do happen where they don't even have to present a case, and you can't hold it against them because the burden is simply on the state. So, if the prosecution can't prove Carmelo was reasonable in fear for his life and also a reasonable person, they have to let Carmelo go. Now, the question is, what is a reasonable person? What's that standard for being a reasonable person? So, Texas Penal Code, section 9.31 says a person is justified in using force when they reasonably believe it's immediately necessary. What does reasonable mean to you? So, in stand your ground, kind of twofold. You have to prove that that person really wasn't in fear, or you got to get into that person's mind and try to prove that they weren't really scared like that, which is very hard to prove. So that's why they kind of make it as a reasonable person too. If I was in that same similar situation, just a reasonably prudent person, just if I was to pick a random person off the street and say, "Hey, if this happened to you, how would you react?" And if I pick 100 people like that, in 68.2, which is the majority on the bell curve, if the majority of them says, "Oh, I would do this," then that would be the standard. That would be the standard. That's what the reasonable, prudent person is, a reasonable person. So it doesn't matter. It doesn't matter if this person's a tough guy and it probably was hurt. The law always going to ask the same question. Would a regular person in this situation felt the same way if they got jumped? If I was in this situation, if I put myself in Carmelo's shoes and I did what he did, and the reaction happened the way it happened, would I respond something like or similar to how he responded? So that's the standard. The courts have what they call the clean hands rule, or sometimes you might hear it as a clean hands doctrine. It's just simply saying you can't come to court with dirty hands, meaning you can't have done something yourself and try to bring somebody else into court and try to hold them responsible when you kind of did some dirt too. So that's kind of the premise behind that. So what they're trying to figure out is if it was no provocation. So this is actually where the racial undertones and the street dynamics collide. Texas law said you cannot claim self-defense if you provoke the difficulty, basically just starting the fight, or if you were engaging in certain criminal activity at the time. So you can't start a beef, pull out a weapon, and then the other guy react, like I said earlier, and then you claim self-defense that you were defending yourself. So that's essentially the background to the case. It's not really that complicated. This case is not really complicated. It's not really complicated because you don't have to prove that he did it because he's already admitted that he did it. As well, he made statements about self-defense, self-defense. So the only thing you have to really figure out in this case or look for in this case is the provocation. That's going to be the word. Who provoked who? Who provoked who? That's the case. And see, my job as a paralegal is to take all the convoluted and social media stuff and the legal part of it and my own personal life experience and biases and experiences and put it all together and come down to what is the question at law. What's the question at law? What are we trying to figure out? Why are we in court and what are we trying to determine? We're trying to determine who provoked who because this person is claiming self-defense for the unaliving of this person. So hope you guys are learning something right here. Uh, hit the like button, hit the subscribe button, because I will be following this whole trial. Bringing it from the courtroom to the concrete. So make sure y'all hit that subscribe button, because it's definitely going to be some good information shared here. So let's get to the jury selection. So look, right now, there are 600 potential jurors. They're winding them down to about 12. And you need to understand that in Collin County, Texas, the demographics of that jury pool matter. The defense is trying to find people who will understand that in a split-second physical altercation over seating can feel life-threatening. Prosecution is looking for people who think if you brought a knife to a track meet, you were looking for trouble. They aren't just picking jurors. They are trying to stack the deck with people who speak their language. And as a paralegal, I watch the questions they ask, because the questions tell exactly what the story the lawyers are planning to say on. I've heard both schools of thoughts. As a matter of fact, before earlier this live, I was talking to a friend of mine, a good friend of mine, it's a white guy, and he was asking, why did he bring a knife to the school? You can't bring a knife to the school. And that was his question. Like, and I know he's not a racist guy or anything. He hasn't done anything racist to me that I know, and pretty straightforward person. So that is a question to be answered. So we're going to see how they chose the jury, because the jury is going to have to answer that question or find out the answers to that question. So let's talk about voir dire. That's simply just a screening game. So it's a jury selection essentially. And it's a preliminary examination of potential jurors, witnesses by a judge or lawyers to determine their suitability or competence. Now, voir dire can happen anytime in the court case. In the beginning, it happens because you're trying to screen the potential jurors to be in the jury. Sometimes in trial, if a person wants to bring in an expert witness, they'll have a voir dire. They'll stop the case, have a sidebar. The jury will leave, and then they'll talk frankly amongst each other, and they'll question the person, and then they'll make a determination if this person is competent or not. And if they are, then they'll proceed, and if not, they'll strike that person from the witness list. It comes from the Anglo-Saxon legal phrase meaning to speak the truth, and it roots back to the Latin word veris, means true, and dicere means to speak. And the thing about these Latin words that they use that you may see, if you learn what those words are, then you essentially learn what that process or that thing is that they're talking about. So it's important that you kind of learn those words, and you'll understand what it means when you hear it. So lawyers, they don't just ask random questions. They're fishing for bias. So the media and in the legal sphere, they call it voir dire. But it's nothing more than like a vibe check. That's all. The lawyers are handing out questionnaires to hundreds of people, looking for any sign of a juror that has already picked a side based on what the internet rumors are, or even just simply as race. And so there's ways they have to filter those people out. You got to expose dog whistles. So this is how they code race. And I've seen this happen. So legally, prosecutors and the defense attorneys are not allowed to strike a juror simply because of race. That's called a Batson violation. And that's simply like when you violate the 14th Amendment, and you just basically making this decision based on race, can't do it. So because they can't openly just, use that, they use coded language, dog whistles. You know what I'm saying? Like real silent, but it's effective. Because if you know, then you know, right? And you can get the same result that way. Because a prosecutor, they're not just going to go up there and say, "I don't want a black or Latino or brown person juror." Instead, they'll ask something like, "Do you trust the police? How do you feel about BLM or social warriors or social injustice?" And if the jurors say something like they think the system is unfair or biased or sometimes in history or whatever, boom, you up out of there. Get them up out of there. They already have a prejudice or a bias. So you don't want that person because it's going to be hard to get that person to look at the law as it is, not how they feel that it is. And all it takes is one person to hang a jury. So that's why that burden, that standard is so high to be proven. Beyond a reasonable doubt, like it's got to be like no other situation but this one, basically. So if a juror says something like that, it's up out of there. The prosecution going to strike them for just cause, and that's going to be a wrap. Yeah. Now on the flip side, the defense is looking at white people, right? And they look at the white jurors, and they're trying to figure out, well, does this person have subconscious biases? Are they like have implicit biases that they might not even be aware of, or they are? So they might ask something like, what do you think about neighborhood safety? Or how do you feel about black athletes bringing knives to school or to a sporting event? Or bringing a pocket knife. And if they respond in a way in kind, then boom, they're going too. They're trying to smoke out the people that see a black teenager and automatically assume gang member instead of a scared kid defending themselves. Now, this was remember I was talking about talking to my friend earlier, and this was his point of contention. And I had to explain to him, like, okay, so the charge is first degree murder. So you have to prove that while he was at home, he was sitting there thinking that I'm gonna bring this knife just in case, or no, not just in case, because I'm going to do something malicious intent to someone. And then he went there and did that. You'd have to prove that, right? That's hard to prove. But he also was like, "Well, why would you bring a knife to the school?" And I said, "Well, it could be many reasons. I can come up with one off the top of my head. I don't even have to come up with a bunch of them. It takes is one or two, really. But maybe it wasn't because he was bringing it to school so much as it could have been the neighborhood he was walking through or he has to go through to get there. Maybe because he has to protect himself because he's been attacked before." And then he was like, "Well, he lived in a good neighborhood." It's like, well, he probably may have been the minority there. He might have been harassed and he might have needed to felt to protect himself. These are things that we don't know. And if you try to go at that as the prosecution and the defense logically answer that, then it's going to be like, oh, okay, I understand why he did that. Um, so, but it really don't really matter at the end of the day if we're hung up on that part. Like, why did he bring a knife there? Like, it's against school. Yeah, that's not what he's being charged with right now is murder. So you need to look at what the statute is for murder, and it has to fit within those legal elements in order for you to find that person guilty. So that is probably not going to be a deciding factor. It might come up to stir emotion, but it's not going to be a deciding factor. I don't believe. So that's the conversation we had about that basically, and he kind of understood that. Because I'm telling you, the only thing that's really going to matter is who provoked who. That's it. Who provoked who? Who started who? Because that's going to determine if it was self-defense or not. And then, of course, he said, well, a fist fight. It was just regular fist fight. I can't argue with that because according to the law and the statute, that you can't use bodily injury towards a person who's not giving you that. You have to meet it. You have to meet it proportionality. You have to meet force with force, basically. So, and here's a little pre hint to what I think was going to happen is I don't think he'll get found guilty of first degree murder, but he will get found agree. He will get found guilty of second degree murder, uh, because you got to meet force with force. Unless they could just simply prove that he was so in fear for his life, or a reasonable person was fear for their life in that situation, then I would have pulled out a knife too. But if they don't, he's going to get found guilty of the second degree, and that's where I think this is going to fall. The sentences are a whole lot different because if he get found guilty of first degree, it's I think 5 to 99 years. Can't get the death penalty because he was 17 at the time, and that's simply a statute or a law that they have in Texas, which I think is good. Uh, And so essentially, he gets up to 99 years. Now, if he gets caught up on this second degree murder charge, I think the maximum is 20 years. Now, this is where people go wild at because when that happens, right? People that think he's supposed to get life and he ends up getting half of the 20 years, they're going to be like, he got away with murder. They gave him 10 years, he got away with murder. That's not justice. And then there's gonna be some of us that says, hey, wait, he should have got off because he was being bullied and he should have got away all the way. So sometimes you can't make neither side happy. And the law is there to make sure things are balanced and fair. And then they'll both say it was not justice when in fact it was just. He did unalive a person. Like we can't ignore that. And it's a terrible situation for both families that's involved. Both families that's involved. One family lost a member, and the other one is going to be traumatized forever behind this, and have the potential of losing this person for a very long time. So there is no really winners in this situation. Uh, so we're going to look out for that. So let's say, Judge John Roach Jr., he put strict rules on this court case, like you heard. There's no live streaming, no video inside. And, you can only get information and use it old school way on your laptop. And I even heard that they were even trying to record jurors today. See, people are going to make this harder and harder to even court cases to be streamed in this situation because when they're so high profile, it's easy for social media to run with the emotionalism to get the clicks and all that other stuff. And it makes it hard to find jurors that's unbiased because let's just keep it real. You're not going there to find someone who's never heard of the case. If you do, that makes it a little bit easier, but that doesn't mean that they don't have implicit biases. Because if you still ask that person, so what do you think about a kid getting to a fight at a school, and when he pulls out a pocket knife and uses the weapon, and he's like, "Oh my God!" It's like they'll still get him out of there. So essentially, you're just looking for people who can try to look at the law objectively and stick to what the law says, and can separate their own personal feelings and biases as much as they can. That's what you're looking for. So the judge locked the thing down, man. No cameras, no nothing. Because he basically don't want it to turn into a three-ring circus. And also to help mitigate the jurors looking at things online, so they're trying to isolate them and insulate them so that way they can try to keep them away from that. So the jury's going to be picked on Wednesday. I think they're going to come back in, and out of the, I think it's 600 or 300 or something like that, 250 going to come back, and if they're going to get notified if they're going to be in the jury pool or not. I think it's 12 jurors in the alternate. I'm not sure about that, but I know it's going to be 12. So, and then opening statements are going to be on Thursday. So, and while picking a jury, some interesting things happen. There were some questions already asked. You generally don't hear questions that get asked like that. There are questions that get asked, but you don't hear about it. One juror asks, "How do we deal with unconscious bias?" Which is a good question. Judge Roach said, "I think that's why we have multiple people on the jury, because they could test that unconscious bias." Yeah, so if you have a person like can see that you might be a little biased, they're going to check that. That's what you have, a checks and balance system. That's why you have 12 people, so you can check each other. So you can, and if you have a meeting of the minds, that's pretty much, you know, you moving in unison, and that's like what the reasonable common person would choose if everybody can have a collective thought on it based on the evidence. So that was one of the questions that was asked. And another white juror asked about the history of injustice to blacks. And what this shows me simply is that they know that there's a racial undertone in this. And they're simply trying to understand how to approach this because of that. Because we can try to say that the law is black and white, because even the judge said the law is black and white. That's true, but it's not entirely true. See, that's the thing about attorneys. You gotta watch them, because they'll stretch that truth enough where they'll hide that loophole, and they'll know it's there. It's up to you to find it, but they're gonna use it eventually at one day if they need it. But they stretch that truth enough. Um, and and, and let me give you an example, because the judge saying that is basically saying we're not going to do emotionalism, whatever, we're not. The law is black and white, and that's funny because we got a black and white situation going on, but there is gray areas. There's definitely gray areas in law, because the way even the laws are written. Remember we were talking earlier about a reasonable person. That's subjective. That's subject. What was reasonable 10 years ago is not necessarily reasonable now. So that could change. So there's a gray area. There's an absolute to that. There's no absolute that is either black or white. So that's not entirely true. There are gray areas in interpretations of the law, because the laws are written like that with ambiguity. And they leave it open for a good reason too, because you don't want to have everything so matter of fact that there isn't room for interpretation, because things change, cultures change, laws change because of other court cases that happen. And then you can see, oh, this never happened before. We never seen this happen. Let's add that on to this. So you got to have a little bit of wiggle room in the laws. So the law is not completely black and white. It's not. Yeah. There's no way around it. People come with their own life experiences and biases. And you can't get around that when choosing jurors. So the best thing you can do is ask questions and see how that works, and try to make the demographics balance and run with it, because jury selection is probably the most important. Jury selection is probably the most important, because this is where you win or lose cases. I mean, sure, you got to present the evidence and do it the right way and all that, but ultimately it's the jury that you have to persuade. So make sure y'all hit that subscribe button for the People's Paralegal, because we're going to do daily updates on this trial as it moves out of the jury selection into the opening statements. You know, remember, I am a paralegal, not your attorney. This is legal, educational, and entertaining, from the courtroom to the concrete. So I saw some random things before I end this. Some random things out there. You guys might can put in the comment. I'll address them. Random things I saw was like he died in his twin's arm. Now that could be a very true thing. And you guys have to be careful of the sensationalism that they put in the media. Because back again, like these are all tactics. Because even the lawyers know that they're going to go online and see these things. Maybe not the jurors, but the attorneys will. The paralegals do. When court cases are going on and they're streaming live, they do go into the lawyers' chats and watch the shows and get ideas and stuff like that. So uh, they use the media to persuade people a certain kind of way. He died in his twin's arm, like that makes you have a sentimental place right here in your heart. No pun intended, for real, but it does. And speaking of the heart, you hear he was stabbed in the heart. That gives you the perception that Karmelo just simply just went straight for the heart when we're hearing that it was in the chest. Do we know it actually hit the, have we seen the autopsy report? I know there's been reports by some, medical this from the police, and they got to have that slant on their own because everybody's leveraging each other right now. Everyone's leveraging. It's a song and dance. It's a game. It's a justice system game, but you got to learn how to play the game. You can't play the game unless you know the rules to the game. So you got to be careful for little stuff like that because they'll say that and it might not be entirely true, but it'd be close to true. Like another term, life in prison. Yeah, he's up for 99 years, and that's not technically life because what if he lived to 120? You know, he actually lived out his sentence, so that's not life. Life is like without the possibility of parole. Like no matter what happens, you can't get out. But they'll phrase it as life to make him look like a criminal, to show what he's up against, to intimidate him with those words because he's thinking I'm up for life. I mean, essentially 99 years is going to be life, but it's not legally life. Remember what I was saying about what it sound like and what it feel like versus what it is? What it is not really life because, like I said, if Karmelo being 19 right now, if he lived to 122, he should get out of jail for a couple of years. So and put in the chat some things you guys heard you want me to help you guys parse out. Here's your homework. Here's your homework. This is how you stay ahead of the game. You gotta do your homework. And this is for the people that's in the first 1-2 rows. Because like my dad used to say, it's the A row, B row, C row, and anything behind the third row, yeah, you get what you get. Size clowns and everything back there. But here's the homework. Look up Texas versus Cason Allen. That's the legal framework I'm going to be using to guide my decision in this case. Cason, Caysen, Allen, Allen, Allen. Yes, look that up. And I know some of you guys are talking about the Rittenhour comparison, and I will talk about how it doesn't match, but I can see how the comparison can be applied. But I will tell you how it will be applied probably, in my opinion, by the court, by the defense. They're going to use their tactic, but the reasoning is something different, and it's called precedent. Precedent. So we'll talk about that. So that's going to help me make my verdict. And put down in the chat, do you think, is he innocent or is he guilty? Innocent or guilty? Oh yeah, I heard some things about him making statements without being Mirandized. Let me clear that up. You don't have to necessarily be Mirandized if you're giving a confession, heat of a moment confession. If you just start willingly talking without an officer asking the questions, if you just start doing it, they're going to usually just sit there and just note what it is that you're saying because you can either have a consciousness of guilt moment where you just blurt out the truth. It sometimes that happens because the gravity of the situation hit really, really big, and it causes you to do one of a few things: fight, flight, or freeze. You might try to fight it, run off. You might freeze, get scared. You know, you might try to fight it by lying and trying to get your way out of it and make some comments or whatever. So those things happen. But make sure y'all go ahead and hit the like button on the way out. Hope you guys learned something. The street lights are on and court is adjourned.